You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Most likely today, that he would come back clean. He has maintained his sobriety. Judge, he had suffered an injury. His mobility's been inhibited, and he also did, on a positive note, start a new business, a tree removal service. And it was a hard period of time when he was trying to balance his work and the court responsibilities. He understands court has to come first. I'd ask the judge that any sort of admonishment or sentencing be delayed to at least demonstrate that my client is remaining sober, clean, and absent drugs and alcohol.
Anything you would like to say?
No, that's correct, Your Honor. I've had some difficulties here with, my partner is in the hospital as we speak. And I had to go with some, independent contractors, of which 2 of them, so he didn't have a driver's license. So I was doing driving and trying to keep trees from falling into houses. I mean, I had some emergencies going on and I just got a bad time.
It's not good.
Clean, and I want to get back on the program. I finished ILP. I'm doing OP now. I'm doing my meetings. Everything is,
I told you from the beginning, if you didn't test, I was going to assume it was a positive test. You're losing this battle, man.
I really believe I can do it here.
Okay, well, but I can only give you so many chances. This is 8 violations now. Anything?
Your Honor, my concern is he missed a test in January. We talked about it, gave him a verbal warning. And then here in March, practically, half of March now, he's only shown for 1 chemical test. My concern is drug of choice. We're not talking about alcohol in this circumstance. It was drug of choice, cocaine. It's in and out of your system fairly quickly, within 1 to 3 days. We have essentially what I would do is back-to-back testing now, and over a holiday as far as, how you view St. Patrick's Day. But it was St. Patrick's Day weekend and St. Patrick's Day. He doesn't show for testing. He's delinquent in some areas of probation, nothing that kind of warranted a violation at this point, but he's due to still provide us with proof of a victim's impact panel completion. His community service was due March 1. He owes 56 hours. I've talked to him several times about it. I don't know where to go. I know he's in this program after having violated traditional probation as far as entering sobriety court a little bit late. So I have lots of concerns. I can understand 1 missed test based on all this issues with business and what have you, but to basically miss all tests but 1 in the first half of a month is pretty darn severe, pretty darn big.
You want to do the program?
I do.
I don't think you do.
I know it doesn't look like it, but I've had a lot of success.
I'm going to give you 7 days jail right now. You're going into custody for 7 days. Next miss, next positive test, next screw up, I'm revoking you. We're done with you. You got me? You understand?
Yes.
7 days jail forthwith. I didn't think you were going to make it.
And I do have to ask, is it possible to report date?
No. Why do you have to ask that?
Because I always ask you.
Do I give report dates? Usually I don't think so. But hey, I get it. It's
Excellent.
Mr. Bologna.
Good afternoon, Your Honor. Anthony Bologna, Bennett City Judge.
So I'm not gonna make an issue of it. Your motion was filed yesterday. You can respond verbally, Mr. Bologna,
I
okay?
appreciate that, yeah.
Okay, go ahead.
Thank you. So we received the motion yesterday afternoon. Our response would be that,
Well, wait, let him argue first.
all right, go for it.
Go ahead.
Okay, let me go first?
Yeah.
Okay, my motion. All right, thank you, Judge. I think it's self-explanatory, the motion. I believe it's right on point respectfully. We want, the court rule says about the interest of justice prior to sentencing, about a motion, if the plea itself was not defective, by the court or by the attorneys, which we're not challenging. We're saying the interest of justice is the standard by court rule. And that is, it's almost, I wish all my cases were so clear cut, at least in my opinion. And that is if somebody is a diabetic and the law and the science is crystal clear that taking a breathalyzer is just not accurate. In fact, the officers are informed on their sheets that if somebody's a diabetic, not to get blood. And also the statute, I don't have it right this second, but I could have it in a second. That the only is blood and urine is permitted, obtaining a reading for blood alcohol content when somebody has diabetes. And it's crystal clear my client has diabetes. We have all the medical records for that. I didn't, unless it's sealed, I didn't want to provide those to the court. He can swear to it. His doctor has a letter that says that he's a diabetic. In fact, the letter says that it can cause artificial highs, and not negatives, but positives, in taking any type of a breathalyzer reading. And that's why it's blood only. So, Your Honor, I don't fault the officers. Of course, they gave a breathalyzer. But in the interest of justice, this is a very important case for my client, like it would be for anyone. And he's a medical doctor, and licensing in that. And so, it was a .09 and a .10. And if it was artificially high, what was his real blood alcohol level? 0.02, 0.03, 0.04 maybe, and it's artificially high. So in the interest of justice, and Judge, I've been 40 years, but however long the court's been on the bench, I presume about 30, is that I've never brought a motion like this in this building. And so I truly believe that we have good cause in the interest of justice by the statute or by the court rule, that it would be not fair to set it aside prior to the sentencing and allow him to proceed to trial. In the event the judge was Your Honor was kind enough, for lack of a better word, to set it aside and set a trial, that would be a for sure trial day that would go. I don't expect it to be any more at all than a one-day trial. Thank you.
Mr. Maloney?
Excuse me, quick reply. And that is, my client was never advised against the attorney. Unfortunately, I don't think practice that area of the law, at least beyond pleas. That is very important and it's instrumental and material in giving a breathalyzer that if you have diabetes, then the acetones, and I put a little bit more of the scientific terms in the motion. Thank you, Your Honor.
Anything else, Mr. Maloney?
Better.
Except as provided, this is under 6310B. Withdrawal after acceptance but before sentencing. Except as provided in subsection 3 after acceptance but before sentencing. A plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn. Withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. I don't know that it would substantially prejudice the prosecutor, but I can't find that this is in the interest of justice. As Mr. Bologna pointed out, there were lengthy discussions that occurred on the date of the trial. There were numerous pre-trials. I remembered when you said sidebar, Mr. Kolovis, when you were here for sentencing,
Yes.
that this was based upon the fact that, primarily, that this was based upon the fact that he was a diabetic.
Correct.
I had read the report, which I never do. I'd read the police report, which I never do before there's a conviction on it. I'd read it the date of the sentence, which I always do when I'm going to sentence somebody. And if you look at the report, it says, Pastor informed me he did not suffer from any injuries other than some back pain. He denied being a diabetic. He stated that he had no recent head injuries. He stated that his highest level of education obtained was a master's degree. He informed me he could understand everything that I was saying. So while your client is now advancing this argument, or you are, I suppose, on behalf of him, the police report clearly indicates that he told them that he was not diabetic. I'm sorry, I'm going to deny your motion.
Your Honor, just, if I may, just for the record, just make a record. And Your Honor, he did not say that. And it's on his listing of his medication. And there's a letter from his doctor talking about
Well, I
it.
don't know how they're supposed to be mind readers.
But even if they,
Listen.
nobody says they are, nobody says they did anything wrong. I'm
It
just saying.
says he
the interest of
denied,
justice.
he denied being a diabetic.
That doesn't mean the results.
That means that they might have taken other steps. And this is a decision I'm not gonna reverse myself on. I've thought about this. The interest of justice do not require setting aside the plea. I will be happy to let you appeal this. I will sentence him. You can file your motion to stay any punitive measures pending the appeal. I'll be happy to do that for you.
You don't judge, what happens if somebody is raped and they're serving 50 years and the DNA comes back? And the person said, I'm
Mr.
guilty,
Globus, I heard you. I made my decision.
doing my talking, all right.
Do you want to sentence now? You ready for sentencing?
Your Honor, I would ask this, may we be allowed to do an interlocutory appeal?
No,
immediately?
I'm going to sentence.
You want a sentence?
Yeah, you can take your appeal and you can do, I will stay whatever's punitive.
I appreciate that, Judge. I suppose, go ahead and,
Okay,
with sentencing.
all right. So have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
If I may have.
Sure.
No? Yeah, go ahead. I understand your prescription.
Listen, Mr. Pastor,
Yes.
you guys can take an appeal. I'm not trying to jam anybody here. You told the police, according to the report, you denied being a diabetic. I don't know what they're supposed to do. Now even the police officer is lying in a police report, which listen, I'm not going to listen to this anymore. I made my decision. Nobody has ever heard me say I'm always right. Not one person's ever heard me say that. I'm moving on. We're going to sentence. And then you can take your appeal. I have no issue with that.
Thank you, Judge.
All right, is everything in this report accurate?
Yes, Your Honor.
Any, no material additions?
You have to leave.
Okay. Anything you would like to say on his behalf?
Your client, my client is a medical doctor. Medical profession, and he runs several offices with his wife, who's a medical doctor. He denies, and I understand the plea of guilty to him, but given the other circumstances now that he relied upon, he denies that, he was under the influence that day. Thank you, Your Honor, nothing further.
Sir, anything that you would like to say before I sentence you?
I have been prescribed metformin for the past year and a half. Got all my prescription. Nobody has ever asked me. I do not recall if the officer has asked me. I'm diabetic or not.
Can I see your AA attendance?
The guy in the car.
Pardon?
He may have it in the car. Do you want him to go to the car?
Do you have him in the car? Have you been going twice a week?
Yes, I will. Here. Picture. The guy. Can I put in my vehicle to
May he go to his vehicle, Your Honor?
Sure.
3 minutes.
Sure.
I think you want you run out there and go get it. I'll reach back. You'll pass.
I'll tell you what. Come on back up here. Let's just finish the sentence. You give them the probation afterward, okay?
Okay, Judge.
All right. Anything else, Mr. Pastor?
No, I'm not sure if any of my medical letters was being presented properly. And that was one of my main concern because of the fasting, my ketone levels at that time, and I haven't prescribed 1,000 milligrams of metformin. I got my prescription history for the last 2 years. I just emailed that to Mr. Gross. I've been prescribed for diabetic medications, but I take every single day because my weight went up to almost 200 pounds after the.
I know, but you're not gonna argue with me about my decision.
That's not my intention. And I wish this would have came to resolution way sooner, and our previous council would have presented this text as well too, which I'm just coming aware of it, is not, none of this was being really properly presented. And I'm very disappointed about that, because that should have been presented properly in a timely fashion. That was not my intention whatsoever to take this to this far out of context. That was absolutely not my intention. It was not my intention. I asked him to present the facts properly a number of times, and it has not taken place.
I don't know I didn't see anything that your lawyer did wrong. You didn't see anything your lawyer did. Listen to me. I don't want to quarrel with you. You denied that you were a diabetic according to the police report. Now, if somebody tells somebody that they're not a diabetic, I don't know how they can raise the defense that, yes, he really is a diabetic. He was just kidding, and they should have taken different procedures. Now, I don't want to dispute this with you anymore. I've had this feeling the whole time, Mr. Pastor, that you don't think you did anything wrong. You really don't. And you had one 4 years ago, and you're only what, 46? You get one in the next 50 years. That's a felony.
We're not getting on.
Well, I know, but nobody thought you'd probably be back the second time either.
It was not my intention.
Mr. Pastor, let me finish. It's my turn to talk.
That's-
If you have something else you want to tell me before I sentence you, I will be more than happy to listen, but I'm not going to go back and talk about your lawyer. I don't see what he did wrong. If you have something else you want to say that's going to cause me to be lenient, I'll be glad to listen, but please. Do you want to say anything else?
I'm not here to do anything plus. He's such a nice guy.
I don't want to talk about Mr. Zelnick.
Of course. I do not recall the officer asked me if I'm diabetic. I'm taking diabetic medication every single day. I listed on my medication sheet. I'm taking diabetic medications. I told it precisely every single day. I'm taking 1,000 milligrams. It's the highest milligram of metformin you can take. That's for type 2 diabetes. I mean, literally, I was getting heart disease. If I don't take that medication, I sent him, show him my,
Mr. Pastor,
He's passed that right now, the judge.
and
He's not gonna upset the judge.
you can appeal this. I've never, like I just told your lawyer,
to upset you.
you're not upsetting me, but I'm not going to allow people to argue with me after I've made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Not my intention, Lord.
12 months probation. You're to submit the chemical testing, PVTs, and ETGs bi-week. You're to attend AA and A twice a week until in treatment. Once you get in outpatient treatment, you no longer have to go to AA or NA. You're also to attend the Victims Impact Panel. 5 days jail credit, 1 served 4. I'll let you serve those as follows. 2 days on the court work program. Those have to be completed by May the 1st. I'm sorry, 2 days court work program. They'll schedule on those, and 2 days of community service by May the 1. Fines $300, costs $300, 75 victims' rights fee, $50 justice assessment. That is 7 1/4. Screening fees 60 for 785. Probation fees are $240 for 1,025. You have cost of recovery of $150 for 1,175 plus $70 in court work program fees, $1,245. You may be eligible for early discharge. If you complete all this in 6 months, you can apply. If you violate, your probation could be revoked. You could be incarcerated for up to 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Now, what I'm going to do, Mr. Kolobus,
Yes.
I'm going to indicate on here, defendant need not report, and will you tell probation this, Amy, need not report. Well, look, I'm prepared if you appeal, you file a motion with me, and I'll make his fines due on May the 10th. And, but he's gonna do, you can file a motion and I will stay anything that's punitive. I'll stay which I don't consider to be AA, outpatient or victims impact panel. I do consider it to be court work program, community service, or payment of fines.
Okay, thank you, Judge.
So you can file a motion when you appeal, and I'll be more than happy to stay anything that's punitive, but you gotta come in front of me and we'll figure everything out, okay?
Consider it, Judge, thank you.
And then he's gonna go meet still with probation, because I do need him to test. I want him to test bi-weekly, okay?
Yes.
And I won't make your money due until May 10th, and if when we come back, I presume he's gonna file this real soon,
For next week.
I will be happy to extend the time period to pay and to indicate he doesn't have